now in session with the Honorable Chief Justice Cowan presiding. All persons having business before this honorable court are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. Counsel for the appellant may proceed.
Good evening, and may it please the Court. My name is Caitlin Kasuda, and I, along with my co-counsel, Ginevra Ventry, represent the appellant, Northwest Utility Incorporated, in this matter. At this time, I would like to respectfully reserve 3 minutes for rebuttal.
Granted.
Would the Court like a brief recitation of the facts?
Very brief.
This Court is asked to review the United States Nuclear Regulatory Commission, or the NRC, November 2011 Order CLI 11500, which stems from Northwest's voluntary shutdown of its sole nuclear power plant, Silver Beach. Throughout the restart process, the NRC's technical panel, regulatory staff, and director of NRR all recommended favorable restart of Silver Beach effective November 2011. Despite these favorable restart recommendations, the NRC has, in its order CLI 11500, refused to authorize the restart of the Silver Beach nuclear power plant. And one commissioner dissented from that order, noting that this was a unique decision in that Silver Beach was singled out for reasons that were both unclear and inappropriate.
Is it your contention that the findings of the NRC staff trump the Commission's ultimate order in this case?
Your Honor, that is not what Northwest contends. Rather, Northwest was well aware from the beginning that it was going to require full Commission approval to authorize the restart of Silver Beach nuclear power plant. However, what Northwest maintains is that this Court must reverse and remand the NRC's order for 2 reasons. First, because the NRC has exceeded its statutory authority under the Atomic Energy Act and the Administrative Procedure Act. And second, because the NRC has executed an arbitrary and capricious order that fails to follow the agency's longstanding precedent, policy, and procedure, and again, that has singled out Silver Beach.
But why shouldn't we give them the broad discretion that they're granted?
Your Honor, while this Court, as well as the Supreme Court and others, have said that the NRC is entitled to discretion and deference, that there is a limit to that deference. And when the NRC issues an order, one that has no basis in the statute or its regulations or management directives and policies, it leaves no guidance.
Has this Court ever overturned a decision of the NRC?
With respect to favorable restart recommendations?
With respect to anything?
Your Honor, the NRC recently in the Shield Alloy case and in Honeywell was found to be arbitrary and capricious by this very Court. Additionally, as my co-counsel will discuss, Northwest requests that this Court find that the NRC, by its order, has executed a taking which requires just compensation to Northwest.
In Shield Alloy and Honeywell, what was the basis for this Court's overturning the NRC?
This Court found that the NRC was arbitrary and capricious in both of those instances.
How so?
With respect to Honeywell, the Court looked to 2 previous instances where the NRC chose not to apply a rule, the goodwill value rule, to Honeywell in a particular way, and then on a 3rd occasion where Honeywell applied for relicensing, the NRC chose to apply that rule differently. And in Shield Alloy, the NRC refused to, they changed the jurisdiction from the federal jurisdiction of the NRC to the state, but it had applied that rule inconsistently with respect to other parties.
So it was for inconsistent application. Has there ever been a situation where there was a natural disaster, such as the Japanese disaster, that the NRC then acted differently because of, where this Court has overturned an NRC regulation or order?
Not that I am aware of, Your Honor.
Are you aware of any regulation, order, or decision of another federal agency following a natural disaster, where this court has overturned an agency's decision predicated in part upon problems that that disaster caused?
Not that I am aware of, Your Honor.
Is that significant?
While it may be significant, I would point out for this court that the NRC, in its order, did not determine that this plant, the Silver Beach Nuclear Power Plant, was unsafe to restart. And that is the primary duty of the NRC, to ensure that all nuclear power plants, in accordance with 2232A of the Atomic Energy Act, meet that adequate protection standard. And because the NRC has not made that determination, this court must review de novo the NRC's order. As this court has said in Shield Alloy, that when the NRC does not rely on a particular statutory interpretation with respect to its actions, this court must review those actions de novo.
Are you suggesting that we should give no deference to the decision of the commissioners?
That is what I suggest, Your Honor. Yes, this court has said in Railway Labor's Executives that when an agency's actions are not founded on a particular statute or its legislative history, that action is not entitled to judicial deference. And Northwest requests that this court apply traditional canons of statutory interpretation.
But the APA applies to this, right? So if the agency is acting under the Administrative Procedure Act, then the normal standards of review apply, right? And so we only overturn an order if it's arbitrary, capricious, or if there were evidence taken, if there's not substantial evidence to support the decision, right? It's not a de novo standard under the APA ever.
Your Honor, Northwest maintains that this is a de novo standard of review, as the NRC has not relied on any statutory language or its management directives or its regulations. And it is for this court to make those final judgments of law.
I mean, this isn't a question of statutory interpretation, right? If this were, if we were saying, what does this word in the statute mean, then maybe it's de novo review. But where we have a policy decision based on evidence, right, what's happened in the world that the agency's accounted for, that's got to be an APA arbitrary and capricious standard.
Your Honor, this is, in fact, a question of statutory interpretation. Section 2133 of the Atomic Energy Act requires that the NRC impose conditions by rule or regulation upon regulated parties, and that is what the licensing is required. Here, the NRC has imposed conditions upon Northwest that are neither rules nor regulations.
Could the NRC issue an order modifying the license of this utility and make that order immediately effective? If they did that, would that take away your position?
Your Honor, if the NRC had instead modified the operating license, this would be potentially a backfitting modification under the NRC's regulations 50.109, and Northwest would maintain that even in that instance, this would not be successful under the NRC's own interpretation of those backfitting modifications, because the NRC has not found that this was necessary for public health and safety. This Court has said that in Union of Concerned Scientists, that backfitting modifications require substantial additional safety findings, and there was no such safety finding or determination by the NRC anywhere in its order.
When the Commission, under its backfit rule, looks at whether or not to backfit, you're saying that they do not have the authority to backfit if there is no additional risk to the public health and safety?
Your Honor, what Northwest maintains is that the NRC has interpreted, and this Court has said in Union of Concerned Scientists, that backfitting requires a substantial additional finding, that public health and safety requires these additional conditions beyond those of the operating license. Nowhere has the NRC in its order determined that, first, this plant was unsafe to reopen, or second, that this plant required immediate implementation of all near-term task force recommendations to provide a substantial additional public health and safety protection.
So the NRC cannot issue an order immediately effective to put into place the changes in the plant that they want to put into place?
With respect to the recommendations or full compliance, Your Honor?
With respect to the recommendations of their task force?
Your Honor, the NRC is bound by the language of its statute to impose conditions by rule or regulation. These recommendations are neither. And as such, the NRC has exceeded its statutory authority by requiring implementation of these recommendations that, again, are neither rules nor regulations. If the NRC wishes to require these modifications, it should engage in the proper notice and comment procedures required by the...
So you're saying that the NRC can never order immediate compliance with any adjudicative determination? It can never do it by adjudication. It can never do it by anything but a rule or reg.
Your Honor, the statute requires that when they impose conditions, they are by rule or regulation. And I do understand that the Supreme Court has said in United States versus Mead that it may impose conditions via adjudicative orders. However, this was not an act of agency policymaking. This was not rulemaking. This was the Silver Beach nuclear power plant being singled out by the NRC. And that is not only an excessive act.
Singled out because there was a big problem with a very similar nuclear power plant in Japan that almost blew that itself to smithereens. And can't the NRC, in its political discretion, take that into account?
Your Honor, as the Supreme Court has said in State Farm Mutual Auto Insurance, an agency cannot consider factors beyond those that Congress intends it to consider. And political pressure is not a factor that the NRC is authorized to consider.
Where do you see political pressure in this?
Your Honor, the record appears to indicate that the NRC, in September 2011, issued a general order, CLI 1105, which concluded that there was no imminent risk to public health and safety posed by continued operations at all U.S. nuclear power plants. In October of 2011, the NRC received over 2,000 letters, most of which were form letters, from Cascadia citizens requesting that the NRC refuse the restart authorization of Silver Beach and impose all the near-term task force recommendations. And in that same month, the NRC received a letter from Congressman DeFranco urging the NRC to again refuse to authorize the restart of Silver Beach, and stated that if it did not, then Congressman DeFranco would urge Congress to review the actions of the NRC. And then...
Are citizens not permitted to petition the NRC even through their elected officials?
Your Honor, the citizens are permitted to petition the NRC. That is precisely what the NRC's 2.206 petitions orders are for, and that has happened in this case. But those petitions should not have been received by the NRC, or should not, and nor should they have been approved by the NRC, because they fail to meet the NRC standards of requesting any relief. And additionally, not only has the NRC exceeded its statutory authority, but this again was an arbitrary and capricious order, one that has singled out the Silver Beach nuclear power plant and considered impermissible factors. The NRC cannot simply divert from its own management directives, its policy and precedent, without providing a substantial justification for its actions, so that all regulated parties understand when the NRC chooses to implement policy and when it chooses to divert from its policy. Here, this Court has recently said in Rampar-Cash versus the Federal Aviation Administration that diverting from a management directive by simply stating that it's important not to apply that directive is not a substantial justification. Here, the NRC, in its order on page 6 of Attachment G, has said that it was important to implement near-term task force recommendations, but nowhere did it state that it was even considering its Management Directive 8.100, which requires that it only consider the conditions that lead to a shutdown when determining whether or not restart authorization is permitted, nor has it looked to any of its precedent and procedure. And I would note for this court that there were other plants, not only the Stewart Valley plant, but plants that had a similarly poor history to that of Silver Beach, as stated on page 11 of the case memorandum, that were permitted to restart without implementing a full compliance standard and without implementing the near-term task force recommendations. So undoubtedly, Silver Beach Nuclear Power Plant has been singled out by the NRC, and it is for this court, as Northwest requests, that this court reverse and remand the NRC's order because it fails to comply with the statutes set forth, the language of the Atomic Energy Act and the APA, and because this was an arbitrary and capricious order. Thank you.
Thank you, Counsel. Proceed.
Good evening, Your Honors. May it please the Court. My name is Ginevra Ventry, and I will be discussing the takings issue this evening. A Fifth Amendment taking is an example of the economic deprivation that results when an agency acts outside the bounds of its statutory and regulatory framework. This Court must further hold that the NRC's order constituted a taking under the Fifth Amendment because it completely deprived Northwest of all productive use of the Silver Beach plant by indefinitely postponing its restart.
But didn't they deprive themselves by not complying time and time again and voluntarily shutting themselves down?
Your Honor, with regard to your compliance concern, that was one factor in the order itself. And as my co-counsel explained previously, they considered factors that were not those that led to the shutdown. However, regarding the NTTF, the Near-Term Task Force recommendations, there is no explicit end date or release date for those NTTF recommendations. Nowhere in the order does it stipulate when or even if there's a possibility that Silver Beach will ever reopen. In fact, on page 6 of the order itself, the NRC expressly stated that if the Near-Term Task Force released recommendations, then Northwest would be required to implement those recommendations. However, the NRC cannot add a condition that is merely based on situation. Now, in regards to the order at hand.
What is the status? Have those recommendations been promulgated in full?
No, Your Honor. The status of the 12 recommendations to which I believe you're speaking, they were prioritized, yes, after the order, and I must emphasize after the order in this case. But also, the NRC expressly stated in its CLI 11500 order that it may release, there's a possibility that it could release recommendations in the future, and that Northwest would be required to implement these hypothetical recommendations.
Isn't there some period of time that we should allow the NRC to proceed before it gets to the level of a taking? In other words, shouldn't we give them, whatever, a year, and maybe a year after the takings issue's been raised, then revisit this?
No, Your Honor. I believe you're speaking to the principle laid out in Tahoe Sierra. Now, that was a United States Supreme Court case that dealt with an action by the government that was an explicit clear-cut temporal restriction on land use. It was for a duration of 32 months. And the landowners knew that there would be a ban on development in the Tahoe Basin for exactly 32 months. And in that instance, the United States Supreme Court found that fact controlling, in fact, that the landowner could anticipate.
Right, but Tahoe Sierra involved a particular time frame. This doesn't. But what this does have is an end date that just hasn't been finalized. It's sort of it's a non-perfected end date. It will end when the recommendations are released and they're implemented at the plant. And that is, this isn't a situation where they've said, we retain entire discretion to maybe authorize you to proceed and we'll let you know if we decide to exercise the discretion. It's a situation where there are sort of two contingent events that have to occur, and when they occur, it reopens. And I guess my question is, given that, shouldn't we as a matter of law give them some kind of grace period to actually do what they said they're going to do? And wouldn't something like a year be a reasonable period? And why shouldn't we, whatever we do on the other issue, why shouldn't we dismiss your case without prejudice for, so that you could refile it after a year or stay it or something like that?
Certainly, Your Honor. Let me clarify that factor. Yes, exactly as you stated, there's a possibility that the near-term task force will release these hypothetical recommendations. However, in Tahoe Sierra, the United States Supreme Court expressly stated that it did not want to put a time requirement as to which you refer on these takings analysis. In fact, what it finds controlling is that in a situation like this, if you were to analyze it under the Penn Central Transportation Company case, which this instant order would be analyzed, again, if it had that express end date, a la that 32-month moratorium, say, in fact, there was an end date in this instance, perhaps November 14th, 2012, in which the Northwest knew that the Silver Beach would restart. It would be analyzed under Penn Central, and then at that instance, you engage in a balancing test among three factors. You look at the degree of economic deprivation, you look at any interference with investment bank expectations, and you look at the character of the government's action at issue. And in that instance, then you balance the economic deprivation within that particular time frame. And in here, within this indefinite time frame, per month, Northwest is losing, based on its 2011 earnings, $20 million per month in lost revenue. And compiled on top of that, its shareholders are paying $2.4 million per month in replacement power costs. And in Duquesne Light v. Barish, the United States Supreme Court expressly stated that when the utility is barred from earning its rate of return on equity, which in this case, Northwest's rate of return on equity has been reduced from 10.5% to 8.5% as a direct result of the NRC's order, then the government has taken that property without just compensation and must pay the property owner, or the utility in this case, for their loss. Now, in Lynch v. United States, again, the United States Supreme Court clarified that contract rights are property rights and thus fall within the purview of the Fifth Amendment's mandate that private property shall not be taken for...
This is
Consul,
a plan. Go ahead.
Consul, if NRC had issued an order that they made immediately effective, and made it immediately effective for the Silver Beach plant, among others, in which they mandated certain things that were required to be done by the plants as a result of Fukushima, would there still be a taking?
If it had an express end date?
Assuming the order had an express end date.
Certainly, Your Honor. Because it had an express end date, it would be analyzed under Tahoe Sierra. And the controlling factor in this case is that the NRC keeps on moving the goal line in this instance. There is no Northwest as a utility, and in fact, to broaden the scope here, as a regulated party, has no idea when they will again be able to have productive use of their property.
But doesn't the NRC move the date because they are constantly learning new things about the Fukushima accident that cause them to need to improve their orders and their positions with regard to what a utility in the United States must do? Isn't that why they're moving the date?
Your Honor, in general, if the NRC would have given a general order to all regulated parties like Northwest, that would be a different case. However, the order in this instance solely applies to the Silver Beach plant. And it must be emphasized that a month prior to Fukushima, the Silver Beach plant sustained a 6.8 magnitude earthquake, and the NRC concluded that there was no significant damage to that plant. And furthermore, Silver Beach sits 110 feet above sea level. Therefore, a tsunami threat is not an issue here. Now, looking back, that speaks to the third factor of Penn Central, I believe, Your Honor, because that looks to the character of the government's action at issue.
Has the Supreme Court ever affirmed a taking determination under the Penn Central test?
Looking to the Penn Central test in this instance, in regards to an indefinite order?
In regards to any order.
Affirmed a takings place?
Yeah.
Not that I know of, Your Honor.
Right. Has this court ever affirmed a taking claim under Penn Central?
Not that I know of in this instance, but we're presented with unique facts, Your Honor, in this case. We're presented with a regulated party who has no idea when these potential factors, these potential recommendations will be
Right. Part of the Penn Central rationale is we don't want to upset reasonable investment-backed expectations, right?
Certainly.
If you invest in a nuclear power plant with a record of continually poor maintenance, violations of rules, et cetera, of the nature of your plant, why would you have any expectation that the plant would be allowed to continue to operate?
Your Honor, with regard to the poor history, my co-counsel explained that in this instance, the NRC was required to consider the factors that led to the shutdown. However, with regard to investment-backed expectations, in Cienega Gardens, the Federal Circuit clarified that some expectations are unreasonable, Now, Northwest could not have expected that the NRC would exceed its statutory authority or go beyond its adjudicatory precedent, and that is what is at issue in this case. And furthermore, in regards to...
No, I understand that, but the point is you're an investor, and you're trying to, say, choose between some investments, right? Mm-hmm. I could invest in a blue-chip stock, or I could put my money in a nuclear power plant with this terrible record. Maybe your return might be bigger in the nuclear power plant, but surely you recognize that you have a much bigger risk in investing there because, you know, under the circumstances, the federal regulatory agency might say, we're going to close it.
Certainly, Your Honor. And in this case, under that second factor of Penn Central, you look at the expectations of the property owner. You're looking at Northwest, and you're looking at the fact that they invested in a plant designed to sustain significant earthquakes of significant magnitude here. And in addition, Northwest has invested in a tiered system of energy production in order to meet the Cascadia Rates Board's clean energy standard. And what that is, it's a percentage requirement in Cascadia that utilities maintain a certain percentage of their energy portfolio as clean energy. Now, Northwest expected, since August of 2011, when the director of NRR sent it a letter stating that it would reopen in fall 2011, that it would reopen it again at that date. Now what it's faced with is a change in the character of its investment to meet this clean energy standard.
Is there anything in the order that suggests the NRC will never allow this plant to operate?
Absolutely not, Your Honor, but there's also nothing in the order that states that the Silver Beach plant will ever retain restart. It's simply not enough explanation in the order itself, as my co-counsel explained previously.
When Northwest first applied for a construction permit, did they have a guarantee that going through the entire process that they would eventually get a license to operate this plant?
No, Your Honor. That's not. I suppose that's not the case, but the order, the record is silent as to that point. Now, to emphasize in regarding the degree of damages we're dealing with here, in a takings claim, you want to focus on the pecuniary loss here. And in First Church Evangelical, the United States Supreme Court clarified that when you're dealing with a takings claim, which potentially the court might overturn and make the government agency lift the improperly posed regulation, you look at the date of the order itself, so that would be in this instant case, November 14th, 2011, and you look to the end date of when this court orders the NRC to lift the improperly posed regulation. And what we're dealing with here is 4 months of $20 million of loss in revenue. So that's $80 million up to this point that Northwest has lost with this improperly imposed regulation. And on top of that, you have $2.4 million that the shareholders have lost per month. So that total is $89.6 million that Northwest has lost. And therefore, this court must hold that, Your Honor, I see my time is up. May I conclude?
Thank you very much, Counsel.
Thank you.
Counsel for the appellee.
Your Honors, may it please the Court, my name is Chris Caswell, and I, along my co-counsel, Mr. Mark Assad, we represent the United States Nuclear Regulatory Commission, the appellee in today's matter. Our representation is with regard to the Commission's decision to withhold authorization from Northwest Utility in restarting its operations at Silver Beach Nuclear Power Plant. And there are 3 issues before the Court today. I'll be discussing the first 2, one of which concerns the statutory authority delegated to the Commission by Congress in its legislation of the Atomic Energy Act of 1954. And the second is with regard to the arbitrary and capricious standard of review pursuant to the Administrative Procedure Act. Your Honors, we are here today to preserve the administrative regime employed by Congress in regulating the field of nuclear energy. Now, this administrative regime confers broad regulatory authority to the Commission to carry out its regulatory functions. Now, inherent in this authority is the obligation to protect or promote the common defense and security and protect the health and safety of the public. In discharging this obligation, the Atomic Energy Act explicitly gives the Commission the authority to make by rule, order, or regulation any standard or instruction it deems necessary in order to regulate.
And you contend that you can do it through a sort of a sui generis adjudication like you have here?
Well, Your Honor, not a sui generis adjudication. We have held numerous meetings which were noticed, as you can see on page 8 in the record, and have held meetings with Northwest officials and had an available time for public comment on these regulations.
But you didn't go through the formal notice and comment procedures of the APA, did you?
Well, Your Honor, under the APA, Section 553, notice and comment is required. However, there is an exception to this requirement if all parties are notified thereto of the objectives to be discussed at the meeting, or if they were served and otherwise in accordance with the law. These officials from Northwest were notified of the situation at hand. They knew their current noncompliance with NRC regulation, and also knew of the severe Fukushima accident and the administrative response by the Commission in order to safeguard against a potential disaster happening here.
And what's the relationship between the safety record at Silver Beach and what happened in Fukushima?
Well, Your Honor, what the Commission is trying to do in response to the accident in Fukushima is gather all the information possible it can in order to prevent such a disaster. The obligation to protect the public is exactly to prevent such disasters. We are not trying to equate, if you will, the Fukushima plant and the Silver Beach plant. However, there are glaring similarities, such in design, and similar deficiencies prior to the Fukushima accident.
How do you justify taking action with respect to Silver Beach but not with respect to Stewart Valley?
Yes, Your Honor. Judge Rosenberg, your point is well taken. However, there is in Section 182 of the Atomic Energy Act, which governs commercial licenses, does state a license must be issued on a non-exclusive basis. However, that non-exclusive basis is contingent upon the capability of a facility in question to operate at that adequate standard of protection mandated by the Atomic Energy Act. Now, it is of the Commission's belief, and as elucidated in attachments A and H, that the Northwest has a habitual disregard for these safety standards and has showed an inability to operate at this adequate safety standard. And in pursuant to the congressional policy and purpose, as you will see in Section 1 of the Atomic Energy Act, which is to balance the active participation in nuclear energy along with the health and safety of the public, we feel it is in the best interest of both of those purposes to implement these 12 recommendations.
So what is, I guess I'm trying to isolate, what is really the distinguishing factor between Silver Beach and Stewart Valley? Is it just the history of Northwest's poor maintenance and procedure at the facility, or is it something having to do with Fukushima that affects Silver Beach differently from how it affects Stewart Valley?
Well, Your Honor, the record is silent to the, I guess, the details or the express or explicit situation at Stewart Valley. It does say that it is in a similar situation. However, Silver Beach is the fourth most unsafe reactor in all of the U.S. out of over 100 operating United States reactors.
It's only the fourth most unsafe? That's comforting.
Exactly, Your Honor. It's fourth most unsafe, and it sits on a fault line in Cascade.
Are you saying that the Silver Beach plant does not meet the standard of reasonable assurance for protection of the public health and safety?
Your Honor, it is the Commission's belief, although it is stated in the record that an imminent risk is not the case with regard to all operating United States reactors. However, looking forward prospectively, the object of, or the statutory objectives of the Commission is to prevent future events.
So the Commission is changing the standard?
No, Your Honor, we are not changing the standard. The standard is and always has been an adequate protection to the public.
You're
However,
changing what's required to meet the standard?
Well, Your Honor, it's not that we're changing what is required. What is required is for the appellant to operate in a manner that upholds that standard. We believe that they have yet to do so. As you can see, been in violation over 8 times. As opposing counsel mentions, and I believe you may be alluding to, is the fact that they have it has been stated by the regulatory staff and the technical panel, and also the director of the Nuclear Regulatory Commission, that they could have reopened on November 25th, 2011. However, in the Code of Federal Regulations, Chapter 50, Section 7.4, and establishing these technical panels or these committees, as Judge Rosenberg pointed out during opposing counsel's argument, are independent recommendations only, and the commissioners themselves are not bound to these findings by the technical panels or the committees.
No, you're quite right about that, but I guess the difficulty we're having, and really the crux of this case as far as I'm concerned, is can you justify treating one entity differently from the way you treat a similarly situated entity? And all I'm hearing, and maybe part of it is that the record doesn't fully divulge it, but I'm hearing they've got a bad record, which they do. But does that really mean, as the Chief Justice has asked, or the Chief Judge has asked, does that mean you're unsafe? I mean, yes, they've got a bad record, but what here really justifies shutting them down at this point when the staff has recommended that they be reopened and when a similarly situated entity has been reopened?
Well, Your Honor, if I may point to a reasoning this Court has made in the past in Greater Boston area versus the FCC, where handcrafted orders are necessary in unique factual situations. And in this scenario, Silver Beach presents us exactly with that, a unique factual scenario. While they were in noncompliance with their own license, which I might add the Commission is in its full authority to mandate compliance with its license, the severe accident in Fukushima happened. That presents the Commission with pretty much an ultimatum to make, so to speak.
But how do you overcome that your staff felt that they were now in compliance and ready to reopen?
Well, Your Honor, as expressed in the order, the commissioners themselves were surprised, for lack of a better word, that the staff and the technical panel did not consider the poor performance record and the constant degradation of the circumstances at Silver Beach. I believe what the commission's officers are trying to get to is that the adequate standard has not been met, and from 2002, they've been out of compliance with their license numerous amounts of times. So why, and practically speaking, if I might add, sorry to change direction so quickly, but practically speaking, since they don't have this adequate standard, why not add these implementations now while they are shut down?
But we don't know when the implementations are coming out. Is that right?
Well, Your Honor, we have 12 out right now, and 12, and it is stated in the record, once these 12 are complied with, they will be allowed to reopen. It does state in the record that a 13th and a 14th may come out, and if in the event that it does so, they will be required to implement these. However, there's no indication that they would be required to shut down in the event that this happens.
If the Commission were to issue orders to implement these 12 recommendations and gave other utilities 4 years or 5 years to comply with those orders, this utility would still have to comply with them before it could turn on its license?
Your Honor,
on its plant?
Your Honor, I can't speak for the Commission themselves in the event that happens. I believe the argument that the Silver Beach and Northwest are the only power plant to implement these recommendations is premature at best. There is no indication whatsoever in the record that the Commission will not require other power plants to implement these recommendations.
Right, but the question the Chief Judge was asking is, suppose hypothetically, and it's not actually hypothetically because this actually happened, in the last week? That the NRC says that other power plants have 4 to 5 years to implement these recommendations. Assume that's the case. How do you justify requiring these guys to do it immediately?
Okay, if I may clarify that, for hypothetically, 4 to 5 years, Stewart Valley would get these 4 to 5 years.
Stewart Valley and everybody else.
Okay, 4 to 5 year grace period, while Silver Beach must implement now.
Right.
I believe the response of the commissioners would be the prior performance record and their severe degradation and the position, Your Honors. The high-risk nature of the industry we're in, the nuclear field, plus the geographical position, it sits on a fault line on a cliff. I don't know if that's the greatest picture of stability when dealing with a nuclear reactor. I believe the safest thing to do in this case is to...
But wouldn't it have been designed initially in order to get its license to overcome that hurdle? So it really should not be of paramount concern.
Your Honor, you are correct, and opposing counsel did bring 50.109 up, which is backfitting, which results in a change of position that is new or different than the regulatory staff's position when the license was first issued. When the license was first issued back in 1978, we were absolutely satisfied that Silver Beach and Northwest could operate to adequately give protection to the public. However, in light of the severe accident in Fukushima, obviously the position has changed. It would be foolish to think that the Fukushima accident would not elicit some regulatory response from the Commission, and that's why this position has changed.
In light of Fukushima, is it your contention that this is even a justiciable controversy?
Well, Your Honor, could you clarify?
Well, I mean, obviously the NRC is asking for deference here, but my question is this really a question that the court should even answer? I mean, given the possibility of a major nuclear catastrophe, isn't this something that should be entirely entrusted to the NRC?
Well, Your Honor, I believe the claims of Northwest under the APA do have merit. However, the deference that you mentioned that is given to the NRC should greatly overwhelm this APA claim. However, and I must add that we are in compliance with the APA. We gave every possible notice to Northwest and to the public to come forward and express their opinion regarding these implementations. I would like to point out or touch on the political pressure, if you will, that's in the record that opposing counsel alluded to. The nature of the NRC and the agency, the very construction and the nonpartisan body of the NRC, by its very nature, insulates itself from the executive branch. So any kind of political pressure from Congressman DeFranco should be disregarded, as there would be no ramifications to any of the commissioners in response to a disagreement or acting contrary to Congressman DeFranco's expression.
The NRC is immune, in other words, to any political pressure?
No, Your Honor, not immune. However, the political pressure would be greater, so to speak, if the commissioner could be, or commissioners in its entirety could be subject to something such as being forced resignation or fired or something like that.
How are the commissioners removable of the NRC?
Well, Your Honor, I believe the commissioners under the Constitution have to be removed by a two-thirds vote, if I'm not mistaken. They cannot be removed without cause as well. Your Honor, in sum, we would like to, we respectfully request, in light of the prior performance record, the severe accident in Fukushima, for this court to uphold the NRC's decision to withhold authorization from Northwest Utility and operating Silver Beach Nuclear Power Plant site. Thank you.
Thank you, Counsel. You did not reserve any time for rebuttal?
No.
No, Your Honor, as appellee.
Oh, you don't have a rebuttal. I'm sorry.
How much time did he have left? Let me stop. No, left in his presentation. Okay, thanks.
Sorry. Okay.
Your Honors, and may it please the Court, my name is Mark Acid, and along with my co-counsel, Mr. Chris Caswell, I represent the United States Nuclear Regulatory Commission, the appellee in this case. And Your Honors, as Mr. Caswell indicated at the beginning of his argument, I will address the third and final issue before you today, which questions whether or not the actions of the Nuclear Regulatory Commission constitute a taking under the Fifth Amendment to the United States Constitution. And because the burden on Northwest Utility is not sufficiently strong, and because of the strong interest in public health and safety present in this case, there has been no taking under the Fifth Amendment to the United States Constitution. Your Honors, as opposing counsel alluded to, there are two standards under which this Court should analyze the takings question. The first of which is the Lucas standard from the United States Supreme Court in 1992. In that case, the United States Supreme Court stated that a per se regulatory taking can occur in very specific, limited circumstances. However, Your Honor, those circumstances are not before you today. And a per se regulatory taking finding is not appropriate in this case. And it's not appropriate because all economically beneficial use of the property, specifically the Silver Beach site, has not been deprived from Northwest Utility.
Really?
Yes, Your Honor.
If the NRC had revoked the license, would there be a taking?
No, Your Honor, because under the statutory authority granted to the NRC, the NRC has the right to revoke any licenses that it sees are not in compliance with the standards set forth under the AEA.
What economic use can they make of the facility while it is shut down?
Your Honor, the reason it's not I understand your point, Your Honor, and
I mean, are they going to have birthday parties there?
Your Honor, your point is well taken.
The Silver Beach Glow Fest?
Your Honor, I particularly would not attend. However, that's not the question before the court under the Lucas standard. Because it's only a temporary taking and not a permanent taking, similar to the one that occurred in the Lucas case itself, a per se regulatory taking is not.
But their argument is it is effectively a permanent taking because they have no idea when they're going to be able to restart the plant.
That is the contention of the appellant, Your Honor. And because the NRC has the purpose of promoting nuclear energy and the nuclear energy field in general, it would go against their purpose to continuously add new regulations indefinitely. So if a 13th or 14th or 15th recommendation were implemented and that continued on forever, that would go strictly against what the NRC
So what indication do we have that it won't continue forever?
The indication is the NRC is only imposing standards that it deems absolutely necessary to ensure public health and safety for the future. And once those safety standards are reached, the implementation of near-term task force recommendations or other similar recommendations will cease, and all nuclear power plants will be allowed to resume operation.
And when will that be?
Your Honor, as the court has pointed out, there is no set date. However, the ball is in Northwest Utilities Court, so to speak. And what I mean by that is the near-term task force recommendations, the 12 specific ones, have been implemented by the Commission itself. And as soon as the Northwest Utility operations can come into compliance with those, they will be allowed to restart.
But other plants are operating now without being in compliance with those. Is that not correct?
Yes, Your Honor, that is correct.
So how do you differentiate between what's being required then of Silver Beach and what is being required of other plants which don't have to meet the same requirement?
Your Honor, the 2 points my co-counsel referred to, first of all, the strong indication of a poor performance record, and second of all, the fact that Silver Beach was already in a state of shutdown at the time the near-term task force recommendations were implemented by the Commission. For both of those reasons, it was necessary, in the Commission's view, that the near-term task force recommendations be implemented effective immediately for Silver Beach in particular. And for those 2 reasons.
Mike, I have a question. What is the relationship between the 2 different arguments that you and your colleague have made, right? Couldn't we find in the NRC's favor on the basic question of the shutdown, but also find in Northwest's favor on the takings claim?
Your Honor, that is absolutely possible, and that would fall under the Penn Central analysis set forth by the Supreme Court in 1978. A temporary partial taking is potentially before the court today. However, under the weight of the Penn Central factors, the Nuclear Regulatory Commission contends that a taking has not occurred.
Can there ever be a taking by the NRC with an indefinite delay of making a decision on whether to allow a plant to restart?
Your Honor, to clarify your question, I believe you asked, could a taking occur if there was an indefinite regulation?
Could there ever be a situation where the NRC, by indefinitely delaying,
by saying, here are some things you've got to comply, but we might have more, even if it's not the relationship of 12 versus 1 or 2, but, whatever it is?
Your Honor, I believe I understand your point, and yes, that is possible. And again, that would fall under the Penn Central analysis. It would not be appropriate to use the Lucas analysis, because that analysis is only for permanent, explicitly permanent taking.
Yeah, we hear you on Lucas, but I guess under Penn Central, tell us why there isn't a taking here, but there could be in some other circumstances. Maybe if you distinguish the present case from the other circumstances you're thinking about, that might help us.
Yes, Your Honor. And to answer that, I'll use the specific factors from Penn Central. The first of which, and the most important for this Court to consider in this case, is the character of the government action itself. And in this case, pursuant to the statutory purpose, statutory defined purpose of the NRC, its existence is for the sole purpose of promoting energy, nuclear energy development, and providing public health and safety. And the safety ramifications present before the Court today are substantial. Because of the volatile nature of the field of nuclear regulation and the potential harm as a result.
Excuse me, Counsel. Do you understand the NRC to be in the business of promoting nuclear power?
I may have misspoke. It's in the interest of the NRC to regulate nuclear power and to ensure that it's used appropriately in the United States. And with its regulations, specifically the near-term task force recommendations, that is exactly what it's attempting to do in this case. Also, Your Honors, as Justice Scalia has stated, changed circumstances often require a change in the law. And, Your Honor, the circumstances have changed, quite simply. After the Fukushima incident, which was a 9.0 magnitude earthquake on the coast of Japan, circumstances have changed as far as knowledge and information available to the NRC.
But at Fukushima, the plants shut down properly after the earthquake, didn't they?
Yes, Your Honor. However, that did not insulate it from further damage from other geophysically created events, in particular a tsunami. And while appellant has pointed out that there's a significant difference because of a cliff in the present case, there's no indication from the record or from appellant that other geophysical events could not occur and cause different types of damage. And that's exactly why the NRC deems it appropriate.
Well, this kind of bothers me, I have to say. So it's like on a cliff, right?
Yes, Your Honor.
So are we worried that there's going to be a geophysical event like an earthquake that has it fall off the cliff? And if we are, is there anything they could possibly do to insulate the plant from damage in that circumstance?
Your Honor, I am not a geophysicist. However, I don't know the specific risks associated with being on a cliff and being a nuclear power plant. However, nuclear radiation that could go into the water, which is next to the cliff, is also a possibility.
Right. I guess my point is it can't really be the cliff that's the issue here, because I don't think there's anything that would obviate any harm from some disaster causing the thing to fall off the cliff. The real question is other geophysical events, and since it's not at sea level, it's not going to be subject to getting flooded out by a tsunami. And I'm wondering, are there other things you're concerned about? Are you worried about a hurricane or a bad rainstorm, or what exactly is it that distinguishes them? It seems to all come back to they just have a really bad record, in the past. Is it really anything more than that?
Yes, Your Honor. There is one more fact that is very important for this Court. And while Fukushima was fortunate enough to survive the 9.0 earthquake until the tsunami hit, there's no indication that the Silver Beach site can withstand a 9.0 earthquake.
When was the last 9.0 earthquake in the United States?
1700, Your Honor. In the Cascadia subduction zone, which is actually on the coast of the Pacific Northwest, there was over a 9.0 magnitude earthquake that occurred at that time. And there's no indication, as a UCLA Professor Jan Kagan has indicated, that there's no way to predict earthquakes, specifically in the Pacific Northwest.
Has there been any action by the NRC to shut down the Diablo Canyon plant, which sits on the coast of California, halfway between Los Angeles and San Francisco, about 100 feet up on a cliff?
No, Your Honor, not to my knowledge. I don't believe that reactor has been shut down as of this date.
Then how do you distinguish between that and Silver Beach?
Your Honor, at that point, the safety record does come into play. It is a similarly situated site from your description, and it's likely subject to earthquakes as it sits in an earthquake zone, likely the same earthquake zone as Silver Beach. However, given the poor record of safety violations by Northwest officials, there's an even more increased risk of problems that could occur should an earthquake occur in the future.
Getting back to Penn Central, you were trying to distinguish the Silver Beach circumstance from others. And I guess my question gets to the ultimate economic deprivation and interference with investment-backed expectations. I mean, they've made a good point that, you know, since this thing is shut down and they don't know when it's going to restart, they're losing, you know, gobs of money. And shouldn't the government compensate them in some way for that?
No, Your Honor, because of the strong interest in public safety. Compensation is not owed. As Justice Scalia stated in Lucas itself, when an owner of a nuclear power plant or a nuclear power plant operator becomes aware that that it sits astride an earthquake fault, no compensation should be owed under the Takings Clause of the Fifth Amendment. And, Your Honor, that is exactly what is before the Court today. New information has been learned by the NRC as to the situation that surrounds Silver Beach site. It sits astride an earthquake fault. That earthquake fault, that fault line is potentially volatile and could cause extreme damage in light of the Fukushima facts.
Yeah, but you, getting to one of my colleagues' questions, you guys licensed them to be near the fault line. I mean, I think it would be perfectly rational to me for the NRC to have said, we're not going to allow you to build any nuclear power plants on a fault line, but you did that. And having done that, I don't see how that can be used as the basis to shut them down unless you're going to shut everybody down on a fault line. And then it comes back to, again, the history. And I guess I'm not entirely clear what the nexus is between the bad history and the action that NRC has taken now. Because, I mean, are they still in violation of any pre-existing conditions or rules?
As of this date, no, Your Honor. And there is a nexus. As the Chief Judge pointed out, the reactors at the Fukushima Daiichi plant did shut down appropriately, as they should have, because of the operations at that plant. However, because of the poor performance record and the personnel issues at the Northwest Silver Beach site, there's no indication that those procedures are operating correctly at this point, or will continue to operate correctly in the future. So should an emergency happen, potential issues that occur as a result of Northwest failures could increase the risk and create an even worse disaster than
But at this point in time, they should be operating correctly because the NRC staff was ready to approve the relaunch of this power plant.
Yes, Your Honor. As of November 25th, 2011, they had complied with the pre-existing recommendations and regulations of the NRC. However, in light of the strong public safety concern, the Commission believes that the near-term task force recommendations are necessary for as my co-counsel alluded to, the prospective view of the NRC. It is the entire point of the NRC to protect public health and safety in the future, not just today, not just tomorrow, but for the next decade or the next century.
So the NRC is changing the design basis for this plant when it hasn't changed the design basis for the other plants?
I don't believe the NRC is changing the design basis, Your Honor. I believe they're implementing new regulations that fit onto the existing design. There's not a design overhaul, so to speak. I see my time has expired. Did I answer your question, Your Honor?
Yes. Thank you, Counsel.
Would you like me to briefly conclude?
Say again.
Should I briefly conclude, Your Honor?
In one or two sentences.
Okay. For the foregoing reasons, we respectfully request that this Court uphold the decision of the Nuclear Regulatory Commission. Thank you.
Thank you. Counsel, you have 3 minutes for rebuttal.
Thank you, Your Honor. May it please the Court, Northwest makes 3 brief points on rebuttal. First, as distinguished from opposing counsel's example put forth by Justice Scalia in Lucas, that nuclear operator was was unaware at the time that his operating license was issued that that nuclear plant sat on a fault line. Here, as Judge Rosenberg pointed out, the NRC has issued Northwest its operating license, knowing full well that Northwest has situated Silver Beach Nuclear Power Plant near an area of seismic activity. Secondly, the NRC itself has said, in the wake of 3 Mile Island, in a 3 Mile Island case in 1985, that the prior history of a nuclear plant is minimal at best in determining whether or not restart authorization is permissible.
Was there a history of noncompliance at 3 Mile Island?
Certainly, Your Honor. 3 Mile Island was, after all, the worst nuclear disaster in the history of the United States. And at that time, the NRC required 155 modifications to Units 1 and 3 prior to restart. Third, this Court has said in Catawba County versus Environmental Protection Agency that when an agency treats parties inconsistently, ones that have similarly poor histories or even worse histories than the party that it has chosen to regulate, that is an arbitrary and capricious act. On page 11 of the case memorandum, the NRC authorized the restart of numerous nuclear power plants, apart from Stewart Valley, that had similarly poor histories to that of Silver Beach, without requiring full compliance or implementation of near-term task force recommendations. Yet the NRC, in this case, has singled out the Silver Beach nuclear power plant. For these reasons, Northwest requests that this Court reverse and remand the NRC's order CLI 11500 and order just compensation to Northwest. Thank you.
Thank you, Counsel.
All rise. The court is now in recess, pending a final decision and comments.
Take everything with us.
I think we should all give the competitors a hand.